Hi everyone. Today we'll be studying the cases of bias. Now, in the previous classes, we have read the cases pertaining to personal bias and pecuniary bias. In personal bias, the standard is high. We need to show that there was a reasonable suspicion of bias or a real likelihood of bias. Whereas in pecuniary bias, we only need to show that there is some financial interest of the judge. Now, herein, the financial interest does not mean that the judge will gain something financially, but if in any manner he is anyway related to the case which makes him a party to the case, then in that case he'll not be qualified to adjudicate that particular matter. And this important thing we have learned through the case of Pinochet, right? And the case of J. Mohapatra. In both the cases, it has been highlighted that even if the judge is very remotely related or concerned with the case, he'll be automatically disqualified to judge that particular case. Okay. Now, the case of institutional bias, herein also, the standard of proof is high. It's been considered that only just because the person who is deciding the case belongs to the same institution or the department against whom you have um, been asking for your rights, or you are aggrieved from the decision of that department, and a person from the same department is hearing you, then in that case only showing this is not sufficient. You need to show that there is a real likelihood of bias, that there is a chance that you may suffer injustice. You need to show that. In fact, in USA and UK, if you see, if you call it a policy bias also, it's not being considered as a legal bias, so there it doesn't matter. And further, earlier also we have read, when we were reading what are the problems of administrative adjudication, that in USA, under the Administrative Procedure Act of 1946, they have the system of officers who are independent, and inquiry officers are there, and they are rather, I think they are hearing officers. Inquiry officers are in UK. So in USA, these officers are being attached to a particular department, but they are independent in the sense that they are being appointed by a different public service commission, and therefore their salary, their qualifications, their removal, everything is being taken care by that independent commission. So they will hear all your grievances pertaining to that particular department, but will not be attached, in the sense that they will not be dependent for their decisions and approvals from that particular. Similarly, in UK, we have inquiry officers under the Tribunals and Inquiries Act. So, in US and UK, the problem is solved to a certain extent. And as far as the policy bias is concerned, even that is not considered as a legal bias, because if you see that, for example, the cases that we'll be studying, and most of the cases that come under the case of institutional bias is this, that supposedly the state has decided to nationalize a particular um, service. For example, the transport services. Now all the private members will have an issue with respect to it. So just because saying that minister was interested in that particular policy to be implemented, and therefore he cannot listen the grievance, that is generally not considered to be a right approach or a right contention from, if the judges hear the case, they generally say it's just because you are saying that the minister was interested in implementing the policy and therefore he cannot hear, that is not a right contention to be raised, and it's not been accepted by the courts in India also, because we need to take care of the institutional limitations, or you can say the institutional constraints that are there in India. Otherwise nobody will be able to decide the case. Therefore it becomes important here uh, to further show that there was a real likelihood of the bias. Well, it is not that the case will not be at all accepted. It is not the case. If it is shown that there was an intersection, or there was a conflict of your duty and interest or if you are able to show that the person who is deciding your case has decided the case without the application of mind, or he was acting completely under the orders of his superiors, and therefore he was biased in any way, then definitely there is a scope for you to win the case. But simply saying that the member belongs to the same department against whom I have a grievance will not itself result in the disqualification of the judge who is hearing the case. So, therefore, uh, institutional bias, or what you call to be official bias, very much related to subject matter bias as well. In these cases, the bar is little high, and you need to show that the person who has acted, who has decided the cases, has decided the case with the bias in the sense that he has decided the case in with non-application of mind, or simply without taking the evidence, due care of the evidence. All these things you need to show. So let's read the cases here. This is the Gullapalli Nageshwar Rao versus the Andhra Pradesh State Road Transport Corporation case. Now there are two cases. This is Gullapalli Nageshwar Rao 1. We have Gullapalli Nageshwar Rao 2 as well. Now, in this case, again, it's a matter which pertains to the nationalization of the road transportation, and therefore the private members have brought in their issue and their grievances that it has affected their business. Now, in this case, the secretary to the Road Transport Corporation was given the authority to listen to the cases, all the objections that would be raised against the nationalization, and the final decision, however, was to be taken by the chief minister. So, two contentions were raised in this case. One was with respect to that secretary being the member of the same department, and also the second one that he was hearing the case, but the case was being decided by the chief minister. It violates the idea of judicial hearing, and therefore it has vitiated the entire proceedings. So, with respect to the first contention, the court accepted it, saying that yes, secretary is the member of the department, and therefore he is not the right person to hear the grievances. It should have been the minister who should have heard it. And well, with respect to the principles of natural justice, let's read what the court has to say. It is one of the fundamental principles of judicial procedure that the person or persons who are entrusted with the duty of hearing a case judicially should be those who have no personal bias in the matter. And then they have cited this case and said a judge ought to be and is supposed to be indifferent between the parties. He has or is supposed to have no bias inducing him to lean to the one side rather than to the other. In ordinary cases, it is just ground of exception to a judge that he is not indifferent, and the fact that he is himself a party or interested as a party affords the strongest proof that he can't be indifferent. From the Franklin case, though on a construction of the provisions of that act under consideration in that case, it was held that minister was not acting judicially in discharging his duties. His lordship accepted the aforesaid principle and expressed his view on the doctrine of bias at page 103, saying, "My lords, I could wish that the use of the word bias should be confined to its proper sphere. Its proper significance, in my opinion, is to denote a departure from the standard of even handed justice which the law requires from those who occupy judicial office, or those who are commonly regarded as holding a quasi judicial office, such as an arbitrator. The reason for this clearly is that, having to adjudicate as between two or more parties, he must come to his adjudication with an independent mind, without any inclination or bias towards one side or other in the dispute. The aforesaid decisions accept the fundamental principle of natural justice that in the case of quasi judicial proceedings, the authority empowered to decide the dispute between opposing parties must be one with bias, towards must be one without bias towards one side or other in dispute. It is also a matter of fundamental importance that a person interested in one party or the other should not, even formally, take part in the proceeding, though in fact he does not influence the mind of the person who finally decides the case. This is on the principle that justice should not only be done but should manifestly and undoubtedly be seen to be done. The hearing given by the Secretary, Transport Department certainly offends the said principle of natural justice, and the proceeding and the hearing given in violation of that principle are bad. Okay, um, this reasoning is quite illogical because in the Gullapalli Nageshwar Rao 2 case, just because the matter is not being heard by the secretary but it is being heard by the minister, the court upheld the case and rejected the contention of the parties. But in this case, they have accepted the contention of the parties and said that the secretary should not have decided the case because his deciding is just equivalent to the saying that he is a party in the case because he is entrusted in that particular case, he is from the same institution, he is responsible for executing the policy of nationalization, and he being the same member, it's actually just like that you are deciding a case in your own favor. So, having this idea, the court has accepted their contention and therefore said the decision that was being given by the secretary should be set aside. Now, the second objection that I said was with respect to their personal hearing, and this is a case that belongs to the other principle of natural justice, that is audi alteram partem, that personal hearing should be given, and the person who decides the case should be one who has heard the case, or you can say vice versa as well, that one who hears the case should decide the case. But herein the secretary has heard the case but the minister has decided the case, and this is something against the judicial hearing, and therefore the court said if one person hears and another decides, then personal hearing becomes an empty formality. We therefore hold that said procedure followed in this case also offends another basic principle of judicial procedure. Okay, so but again I like to emphasize that in your books there's one case which is being given, which is Krishna bus service and the state of Haryana. In that particular case, the facts are a little different, wherein the general manager of the Haryana state transport department, he's been made the DSP, the deputy superintendent of police, wherein his duty is to examine the case, examine the buses which are plying on that particular road on the highways. So the same thing is being contested by the parties, saying that he is not the right person to examine the buses because there is an conflict of interest and his duty. Now his interest is definitely he'll be very much lenient while examining the buses of his own department, whereas he'll be very strict when he'll be checking the buses of the private individuals or the private parties, and giving him such powers to an extent that he may completely refuse the running of the buses of the private members. Therefore, it was being said that it is a violation of the principle of natural justice because there is a violation of the idea that there is a conflict between the interest and the duties. A duty should be that it should be very much independent and impartial while examining the working of the buses, the condition of the buses. But in this case, he'll be uh, lenient, and therefore not he'll not be able to discharge his duty with an independent mind. So therefore it was being said, the Lord Denning's lines were being quoted in that case, saying that it's very important facet of administrative adjudication that the faith of the people should remain in the justice delivery system, because if people go with this idea in their mind that the person who was hearing them was biased, then the entire system of administrative adjudication fails. So, therefore, in that case, definitely the judgment that was being given by the general secretary, the general manager of the Haryana State Road Transport Corporation, was being set aside on this ground because there was a conflict of duty and interest. But again, I like to emphasize one thing, that in these cases of institutional bias, and specifically when I talk of India, we have institutional constraints, right? So, therefore, very high standards do apply when we decide the cases of institutional bias. Again, please keep this thing in mind. Now, the another case is of Lalit Modi versus BCCI 2011. Herein, the allegations of corruptions were charged against Mr. Lalit Modi, that he has given some theatrical and telecasting rights to third parties, and also there were some allegations regarding creation of a parallel body like BCCI in London. So the disciplinary committee of BCCI sent him three show cause legal notices and suspended him. So petitioner asked Shashank Manohar, who was then the president of the BCCI and also he was a member of the disciplinary committee, to recuse himself of the case, and then he also did the same. Now, Sri Manohar, when he recused himself, Sri Jyotiraditya Scindia, very famous nowadays, he was appointed in his place, and the other two members of the committee were Sri Chirayu Amin and Sri Arun Jaitley, who were the nominated members. Therein, this person, Lalit Modi, he filed a writ petition in the Bombay High Court and he prayed that the order of suspension be recalled and he should be reinstated, and the three show cause notices be directed to be withdrawn, and the decision to refer the matter to disciplinary committee be also directed to be recalled. Alternatively, he prayed that the first respondent be directed to appoint a mutually acceptable and independent person or panel to consider the replies of the petitioner to show cause notice and to decide whether the allegations are required to be referred to the disciplinary committee or the matter should be closed. Now, he asked Mr. Shashank Manohar to recuse because he was the president of the BCCI and he was also a member of the disciplinary committee by way of the act that was being applicable to him. So he said that that will amount to an institutional bias. He already had a preconceived notion against me, and therefore there's a possibility that he'll decide against me. And also, he followed the suit, he accepted the prayer, and therefore he recused. Now, this person will have problem against Mr. Jaitley and Mr. Chirayu Amin in this case. So he filed a writ petition and he raised these issues. So the first ground of objection was that the committee was not validly constituted. This was on the footing that the rules and regulations of the first respondent society, here in the respondent society we are talking of BCCI, are a matter of contract amongst its members, and the committee should be constituted strictly in accordance with a particular rule. Now, that rule provides for a disciplinary committee consisting of the president and two other persons. Now, the president had recused himself from the committee. The disciplinary committee will have to either wait until the next president is elected, so that committee is reconstituted after including the new president, or if the committee is to consist of three persons other than the president, it should consist of persons who are unbiased and acceptable to the petitioner. So he's saying that Jyotiraditya Scindia should not be the president because he's been temporarily appointed therein. The president should be elected according to the rules of the society. Now, his second objection was that the members of the committee suffered from an institutional bias. The petitioner could not expect fair play from the members who have already been party to the decision to initiate the disciplinary action against the petitioner. So therefore, he is saying that all these people, they were part of a general meeting that had taken place before, and in that general meeting, these people have already decided that they will proceed against him, they will file a case against him, they will suspend him, and therefore he is saying that the members of disciplinary committee should not be the members of the BCCI, and specifically those members who were part of the general meeting. Okay, and therefore he is raising the issue of institutional bias. Okay, clear. Then we move ahead, and the petition was being dismissed by the High Court on both the grounds. Now let's see what Supreme Court has to say in this. As far as the allegation of bias against the members of the committee is concerned, the petitioner had in his letter of 25th May of 2010 objected to Shri Shashank Manohar remaining on the committee. At that time, he did not raise any objection to the other members, Arun Jaitley and Mr. Chirayu. In paragraph 3C of his letter, he stated, let's read his letter, that it is submitted that it is not my endeavor to create any technical hurdle in the process, and no hurdle shall be caused if an independent body constituting of other members of the board is formed. It is submitted that there are only 14 members of the governing council, and hence BCCI can choose and appoint independent persons to investigate into these allegations. Uh, so, when he filed this writ petition, he joined Mr. Chirayu Amin and Arun Jaitley and Jyotiraditya Scindia as the respondents, and he stated in that these members of the disciplinary committee uh, of respondent number one, that is the disciplinary committee of the BCCI. Now, this disciplinary committee has been entrusted with the function of examining the allegations that are being made against the petitioner in three show cause notices which were issued to him. He is challenging the constitution, composition, and continuation of the disciplinary committee. The petitioner is also alleging institutional bias against the disciplinary committee. Uh, and he is, however, making no personal allegation of personal bias or malice against respondents. It's clear that as far as Mr. Jaitley and Mr. Scindia are concerned, the petitioner stated that he was not making any personal allegation or personal bias. He was alleging institutional bias against the members of the disciplinary committee. Okay, so I think this thing is what basis he is alleging that there could be institutional bias, because these were the people, as I told you, these were the people who were the part of the BCCI, and uh, these people have also participated in that general meeting in which this decision was being taken, and therefore he wants that there should be some independent members who should proceed against him if they have to investigate the case against him. So, Mm, against Mr. Chirayo, he has some personal concern. He is saying that he had a 10% share in a party which gave the bid on behalf of the applicant from Pune, and Mr. Sundaram pointed out that the bid of that party was rejected. The only other blame against Sri Amin was that he succeeded the petitioner as the chairman of IPL, and therefore he would be biased against him. So, uh, this is a case of personal bias he's trying to bring before the court, that when he was actually calling for the members to take the rights in the telecom department as well as in the theatrical rights, uh, he has also called for a bid of 10%, and his bid was rejected. So might be, so it's possible that he's having some malice against Mr. Lalit Modi, and also thereafter he became the chairman of IPL. So it's a possibility that Mr. Amin might be having some grudges against Lalit Modi, and therefore it's not good for his case that he should be a part of the disciplinary committee. But overall, he is trying to focus on the institutional bias allegation. Uh, just because they were the members of the BCCI, they should not be capable instituting any disciplinary proceedings against him. But sounds very paradoxical, isn't it? Because if he is responsible for an issue like corruption, then the disciplinary committee of that particular department will only initiate proceedings against him. Well, his idea is that the people who have taken decision already against him, they should not be a part of it, because otherwise it's not possible that no person from BCCI would initiate the proceedings. What he wants is those people who are part of a general meeting in which it was decided that proceedings will be initiated against him, they should not be a part of it. There could be some different independent members if possible. Okay, so let's see what the court has said. Court finally held that the test of real danger of bias is the valid test and not one of the reasonable apprehension. Then they have stated this case decided by the Constitution Bench, and said that it was concerned with the question of bias in the context of sanction to prosecute the ministers. So, in their judgment in para 14, they have observed that question in such cases would not be whether they would be biased. Just Just a second. The question would be whether there is reasonable ground for believing that there is a likelihood of apparent bias. Actual bias only would lead to automatic disqualification, where the decision maker is shown to have an interest in the outcome of the case. Another difficulty that one is confronted with in proceedings held by the committees constituted by clubs is to demarcate precisely the line between the prosecutor and the judge. Then they are citing Justice Mogham's view that in many cases the tribunal is necessarily entrusted with the duty of appearing to act as prosecutors as well as that of judges, for there is no one else to prosecute. So they are also highlighting one of the problem which is there in institutional biases, that many of the cases you will see that the department will be the one who will start the case against you, and you are also having a grievance against the department. So there is no independent person to prosecute and to examine and to decide. So the role of the prosecutor as well as of the judge is of the same person. So this is not something very much new, and therefore in institutional bias it's generally said that it's very much inherent in the very administrative decision making. It's something that you can't help out, because otherwise it will become very difficult to decide the case. For example, in a case where a counsel is charged with the duty of considering the conduct of any member whose conduct is disgraceful and of expelling him if found guilty of such offence, it constantly occurs that the matter is brought to the attention of the counsel by a report of legal proceedings in the press. The members is summoned to appear before the counsel. The counsel's duty is to cause him to appear and explain his conduct. It may be that in so acting the council are the prosecutors. In one sense they are, but if the regulations show that council is bound to act as I have mentioned, and to that extent to act as prosecutors, it seems to be clear that council is not disqualified from taking the further steps with the which the rules require. So sometimes the rules only, the statute provisions only, which will make the party to function both as judge as well as the prosecutor. So in that particular case, you will not disqualify the judge on this particular ground that he belongs to the same department. Okay, so that is one issue that they are trying to highlight. Though it is advisable for a club to frame rules to avoid conflict of duties, if the rules sanction such a procedure, the party who has bound himself by those rules can't complain unless the inquiry held pursuant to such rules discloses malafide or unfair treatment. So that is what I said in the very beginning of the lecture, that if you can show that there was non-application of mind, that there was complete uh, disregard to the evidence and that was before you, or you're completely unfair in your approach, or there was some unfair treatment or a malified, then only you have a strong case. Otherwise, just to say that the person who is from the department is the same person against whom you are having the grievance and is also acting as a judge, it becomes very difficult to consider this kind of pleas. Okay, now in the present matter we are concerned with the question of likely unfairness on the part of the members of a domestic tribunal of a society, and that context has to be kept in mind. Now when we were reading tribunals, I said there's a difference between domestic tribunal and a statutory tribunal. Now BCCI being a society that is being registered in the Tamil Nadu, now that is a society being registered, so it is the rules that have framed are constituting a domestic tribunal, and therefore the rules that apply generally apply to the so-called quasi-judicial tribunals will not apply in very stricto sensu terms to the domestic tribunals, and this thing has to be kept in mind. So the petitioner was alleging institutional bias against the members of the committee, which was only on the basis of their participation in the meetings of the first respondent society, that I highlighted that they had a general meeting. The same thing is being said. In this way, institutional bias can be alleged against every member of the governing council of IPL and the general body of the first respondent, which can't be accepted. So they are saying कि इस तरह से तो you will allege that nobody is competent to decide your case. The petitioner may have an apprehension, but it is not possible to say from the material on record that he was facing a real danger of bias. We can't presume that three-member committee will not afford the petitioner a fair hearing. or that it will not render unbiased findings. Taking a view as canvassed by the petitioner will lead to a demand for interference in the inquiries conducted by all other societies in such situations, and that can't be approved in view of the law already laid down by this court. Okay, so herein they have not accepted the plea of Mr. Lalit Modi, because it otherwise it would render the functioning of societies impossible, right? It would be very difficult for any of the disciplinary committee, any of the inquiry committee, to proceed against their own members, right? If you have this plea that the same department can't proceed against her, and therefore, and also they are the judge, then otherwise the concept of disciplinary committees would be rendered dysfunctional, right? So therefore, in this case, they have highlighted this issue that I have said in the very beginning of the lecture. Okay, so this is all about the departmental bias. So the key things that you need to remember, that the standard is a little high. You need to show that there was a real danger or a real likelihood of bias. Second thing, however, if there is a conflict of your interest and duty and it is being shown to be so, as I mentioned the case of Krishna bus service versus state of Haryana, in that case, yes, the court will help you out. Similarly, in the case of Gullapalli Nageshwar Rao, the Gullapalli Nageshwar Rao won. In that, they have said that yes, because the secretary was the member of the department, and therefore it is a violation of the principles of natural justice. It is violation of rule against bias. But in Gullapalli Nageshwar, in that case, instead of the secretary, the minister was being made to hear the case. And when the parties again approached the court saying that it is a violation, the court said no, now it is not a violation, because the minister is not the member of the department in the same way as the secretary is the member of the department. Here, the minister is only acting as a primary person to execute the policy. Okay, this thing. Fourth, that when I'm saying the standards need to be a little higher, it means that you need to show that the person who has decided your case has acted with malefice, with non-application of mind. He has completely acted under the advice and direction of his superior, and therefore he has not acted independently, and therefore the case or the decision need to be set aside. So these things you need to show. Other thing that I said was, in US and in UK the problem is little bit solved, because there they have the system of inquiry officers or hearing officers who are independent, although they are attached to the department, in the way that for every department they have hearing officers. They'll hear your grievances against that department, but they are being appointed by a separate independent commission. So the suggestion herein will also be that in India also we need to imbibe the system that is applicable in US and UK, and probably that is possible. But till now, if it is not here, in India, generally, when it comes to the policy bias, right, generally the plea is not accepted, because otherwise it'll become very difficult in India to implement a policy. Because if a minister who is going to implement that policy, if he will say anything in favor of that policy, the people generally contend that he has already made his mind to implement that policy, and therefore he cannot decide any issue that we'll raise in our objections that are generally called off. You know that when you bring a policy, you call for the objections of the parties. Now when we bring our objections to that particular policy or a bill, right, so therein the hear your objections. So therefore, otherwise, if every time you will say that the same minister or the same department cannot hear your plea because they have already made their mind, because they have published the policy, then it is not possible, it's not going to function. Okay, so these points you need to keep in mind while studying the cases of institutional bias, or departmental bias, or official bias, or subject matter bias, being called by different names in different books and by different authors. Okay, so wish you all the best. Take care. Bye.